Welcome to our module on corporate laws and practice, where we'll be focusing on the National Company Law Tribunal rules of 2016. So what exactly is the National Company Law Tribunal, or NCLT? It's a quasi-judicial body established under the Companies Act of 2013, primarily for adjudicating corporate law matters. It functions as a single window for resolving company-related disputes, aiming to reduce the need for multiple forums. The NCLT was constituted by the central government under Section 408 of the Companies Act, 2013, and began its operations on June 1, 2016, following the recommendation of the Justice Arati Committee. The NCLT handles a broad spectrum of corporate law matters. This includes company disputes, like those concerning oppression and mismanagement, under Sections 241 to 242 of the Companies Act. It also covers mergers, amalgamations, and demergers, as outlined in Sections 230 to 232, and crucially, corporate insolvency proceedings under the Insolvency and Bankruptcy Code, or IBC. Beyond these, the NCLT also addresses the revival and rehabilitation of sick companies, conversion of public companies to private, and class action suits initiated by shareholders or depositors. Essentially, it's designed to hear cases regarding the entire Companies Act and its workings, including operational issues and mergers. Regarding its procedure, the NCLT largely follows civil procedure principles. It has the power to regulate its own process for speedy case disposal, guided by principles of natural justice. The tribunal can summon witnesses, examine documents, and impose penalties. If an NCLT order isn't accepted, it can be appealed before the National Company Law Appellate Tribunal, or NCLAT. Should a decision from the NCLAT still not be satisfactory, the next level of appeal goes directly to the Supreme Court. The NCLT was created by consolidating powers from various authorities. This includes the Company Law Board, the Board for Industrial and Financial Reconstruction, and specific powers of the high courts, related to matters like winding up, restructuring, and reduction of share capital. In fact, upon the NCLT's establishment, the Company Law Board was dissolved, with its functions now consolidated within the NCLT. A crucial point to note is that civil courts have no jurisdiction over matters being dealt with by the NCLT, or NCLAT, as stated in Section 430 of the Companies Act, 2013. Once a matter is before the tribunal, it will be exclusively handled there. The NCLT is vested with the same fundamental powers as a civil court. This includes summoning and enforcing the attendance of any person, examining them under oath, and requiring the discovery and production of pertinent documents. It can also receive evidence, while adhering to specific provisions of the Evidence Act, particularly concerning public records or official documents. Additionally, the NCLT can examine witnesses or documents and even set aside any party in a proceeding. It also holds power regarding the nature of a decree and its execution, meaning it can execute official orders issued by the government, as defined in the Code of Civil Procedure. If an order is against a company, its execution typically occurs at the company's registered office. If the order is against an individual, execution happens where they reside, carry on business, or work. Beyond these civil court powers, the NCLT also possesses specific authorities. It can adjudicate proceedings under the Insolvency and Bankruptcy Code and has the power to punish for contempt of its authority or proceedings, as per Section 425 of the Companies Act, 2013. The NCLT can also delegate its authority. Under Section 426, it can authorize its officers or employees to conduct inquiries, for instance, into a company's officials or members. Furthermore, Section 428 of the Companies Act provides protection for actions taken in good faith. Members, the President, officers, and employees of the NCLT are protected from legal action for acts done in good faith during their official duties, ensuring their integrity is protected even if decisions are challenged. Another key power under Section 429 of the Companies Act, 2013, allows the NCLT to seek assistance from a chief metropolitan magistrate or district magistrate. This enables the tribunal to take possession of documents, books of accounts, or property of a corporate person, though this action requires prior discussion with and informing the respective magistrate. Moving on to a practical aspect, the NCLT now facilitates online filing of cases under both the Companies Act and the IBC. This digital system significantly reduces the immediate need for physical visits to the NCLT for filing. Users can create a login on the official website, easily found by searching e-filing NCLT to both file and monitor their cases online. While online filing is available, a physical copy, identical to your online submission, must still be submitted to the court. However, this physical copy can be sent via courier, further minimizing the need for an in-person visit. Let's quickly go over the key steps for NCLT e-filing. First, for user registration, open Google Chrome and search for e-filing NCLT. On the official website, click Register. Select your user type, like Chartered Accountant or Company Secretary, and fill in your personal and company details, including your professional membership number. Complete the OTP verification via your mobile number and email. Second, once successfully registered, your user ID and password will be emailed to you, which you'll use to log in to the NCLT e-filing portal. Third, upon logging in, you'll choose whether you want to proceed with NCLT or NCLAT and then agree to the terms. Fourth is petition filing. From your dashboard, navigate to Petitioner, then Petition Filing. You'll select the relevant act, such as IBC 2016 or Companies Act 2013, and then choose the NCLT location. Next, enter details like the case type, case title, subject matter, and the specific section relevant to your case. You'll also add details for the petitioner, respondent, and any representatives, such as a company secretary or advocate. Fifth, you'll move to Document Upload. Here, all necessary documents, like your Vakalatnama or petition application, must be uploaded in PDF format. It's crucial to mention the number of pages for each document and ensure that the online uploaded file is absolutely identical in volume and number of pages to the physical file you submit. Sixth, you'll complete the checklist by answering all yes/no questions and then review the entire petition using the final preview option. Seventh, for payment, the applicable fee, for example 1,000 rupees, will be automatically calculated. You can choose your payment mode, either online or offline via demand draft. For online payment, you'll be redirected to the Bharat Kosh website, where you can select options like net banking, debit/credit card, or UPI. Finally, upon successful payment, your case will promptly reflect on your dashboard, confirming your filing. Thank you for joining this module. Welcome to